T. Scott Jones, Banks and Jones. How are you, sir?
I tell you what, just down here at the Knox County Courthouse, playing to win, and hoping like a blind squirrel to find a few nuts.
Oh, you find quite a few. Now, tell us before I want to get into this Jaden Rashada lawsuit and also the back pay that the NCAA, which is in the billions, is going to have to pay to former athletes. But first, tell us how Banks and Jones is different from perhaps different attorneys that are out there.
Well, I tell you what, I appreciate the opportunity, Dave, to explain that. I mean, we're actually the sort of last men and women standing that are trial lawyers. We're down here on a day in, day out basis. I make an average of 41 court appearances a week with the 26 folks that I've got working for me. And I mean, we're here for our clients. I guess you can tell a lot, when your lawyer doesn't wear a tie, it's nothing wrong with dressing down, but that's sort of indicative of the fact that they're not down here, so to be, slugging in the trenches. So we are trial lawyers. We pride ourselves on that. We'll do what's necessary to get you the result.
I got a buddy who's a lawyer in another city, and he will do everything he can to get out of trial. That is not Banks and Jones. They will take care of you. No question about it. What do you make of this Jaden Rashada suit? And in particular, the decision to sue individuals like Florida coach Billy Napier instead of the university as a whole. What statement is he trying to make? What is he trying to prove?
Well, I think, obviously there's a concern that, when you give somebody your word or you promise them something, that there's a consequence for failing to honor that promise. So, as far as singling out Billy Napier and some of the other individuals, I don't know who promised what. We've seen the allegations in the lawsuit, and those have been summarized. And then we've seen a statement by effectively university personnel and defense personnel that they don't comment on pending litigation. But if the facts as propagated by the plaintiff are deemed to be true, I mean, when you mess with a kid's life and they've got a 9-point whatever deal with the U, so to speak, Miami, and you're sort of hell bent for leather to get them to go to the University of Florida, I think that there's a consequence associated with that. You say, hey, I'm going to pay you $13.5 million. It's sort of that sort of Brave New World gunfighter type. I mean, I think that young man's got a right to rely upon it. I mean, that's $4 million. And, I don't know. I don't know what was promised and what was said, but when promises are made, there are consequences for failing to honor them.
T. Scott Jones, Banks and Jones. I'm from the South. A verbal contract, a handshake, that's enough for me. And I know you come from the same sort of upbringing, but does that actually hold up in court? If Billy Napier only shook his hand, didn't sign anything, and said, we're going to give you X amount, would that hold up in court?
Well, it really just depends upon the extent of it. I mean, we've all seen, I think, in our recent Tennessee history, the quote unquote letter of intent. How far did it go? I mean, I can't imagine that it was just verbal discussions. I'd say there were some emails and some other things that went back and forth. I mean, these kids, and I call them kids, I get they're all adults, but, when you are having generation changing money offered, the kid had an attorney. And so he's, speaking with family members and being induced to eschew one contract and say, I'm not going to go to the University of Miami, but instead I'm going to go to Florida, making decisions based upon that. I mean, a lot of it's really just going to depend upon what the proof that eventually comes out. I mean, as we see, I mean, it is a lot on allegations. Now we'll see how much is fact.
So, T. Scott Jones, building off of that a little bit, I wanted to ask, is there a difference in something like this, say a verbal agreement that maybe went too far, that could be a violation that Jaden Rashada could sue for? Doesn't that open up doors for other type of violations? For instance, we know in recruiting, coaches for 40 years now, probably longer, have promised a player, if you commit to me, I'll start you next year, or I'll play you at this position. And then they break that promise and then say, no, we're going to play you at this position instead, or we're not going to start you. I mean, if Jaden Rashada's lawsuit against Billy Napier goes forward, doesn't that open up the door for players to sue a university or to sue a coach on behalf of, this coach broke a promise to me about playing time or the position I'm going to play when I get to school?
Caleb, I think that's a good point, but I think what we're talking about is apples and oranges. I mean, when we're saying, hey, you're going to play if you are the one that has the ability to start, is one thing, as opposed to when you start negotiating with this NIL deals. I mean, it's so new and evolving. There's going to have to be, whether or not we want rules in place or not, there's going to have to be some rules in place so that we don't have these kids. I mean, they're youngsters, and just like we saw in the NCAA lawsuit, and the reason that we saw that, they've got a finite line there as far as their productivity. I mean, I think I said the last time that we were there, Bum Phillips, I was always an Oilers fan back in the 70s, and Bum referred to the NFL as not for long. I mean, these guys got a finite window, and ladies, that they can actually play a particular sport at a level that will allow them to, participate at these Division I schools. So I guess it all depends upon what was said, as opposed to, hey, you're going to start, come here, you're the next latest, greatest thing. I mean, look at Arch Manning. I mean, he's down there, pickled at Texas, and, the whole speculation is Arch going to stay down there, or is and play second fiddle, or is Arch going to go somewhere where he can start? I mean, it's really going to be interesting what happens this fall with regards to our brothers and sisters down there in Texas now that they're a member of the SEC. So I don't know.
Good stuff, Caleb.
Yes. So adding to that, I brought up a conspiracy, and I just want to know your thoughts on this real quick, because theoretically, it technically was against NCAA rules when Billy Napier allegedly promised him $1 million signing bonus if he signed with Florida. Now, I know in light of the recent NIL lawsuits, this could change. We're going to talk about that in a second. But I just want to ask, do you think Florida could be behind this lawsuit because they want to fire Billy Napier for cause? Could they fire Billy Napier for cause over this?
That's kind of some deep state stuff, but I mean, I don't know. Billy Napier's doing a pretty good job at instrumenting his own firing. So I don't know. I think Billy may be following the Bum Phillips thing, not for long in the SEC, but there are a lot of other, programs available. I'm sure that he'd be a good Division II or junior college coach.
Sure, you
Dave,
do.
1 second. But where I was at was,
I mean, that was kind of harsh, but I am a Tennessee fan.
Well, what I meant though was, I think, does Florida want a legal reason to fire him where they don't have to pay out his contract?
Yes.
Well, I mean, we saw Jeremy Pruitt part ways with the University of Tennessee, albeit not exactly similar situations, but making that kind of allegorical argument with regards to maybe Florida is behind it. I mean, I don't know. It is interesting times as they evolve in this whole NIL situation.
I just think it was the guy in a collective going, he made you that promise. Go after him. I think they dropped that little hint. I don't know that after it, like Caleb used, was the word I would use, or behind it, but I think there was something there.